Nidal Hassan. On November 5, 2009, a United States Army major walked into the Soldier Readiness Processing Center at Fort Hood, Texas, sat down at a table, and bowed his head as if in prayer. Then he stood up, drew a pistol from beneath his uniform, and opened fire on the room. Over the next 10 minutes, he moved through the building firing more than 200 rounds from a laser-sighted handgun. When the shooting finally stopped, 13 people were dead and 32 more were wounded, making it the worst mass shooting on an American military installation in the history of the country. The man responsible was Nidal Malik Hassan, an Army psychiatrist whose entire job had been to treat soldiers returning from combat. And more than 16 years later, he is still alive at Fort Leavenworth, waiting on a signature from a president that could finally end the case. Nidal Hassan was born in Arlington, Virginia in 1970, the son of Palestinian immigrants. He joined the Army out of college, spent nearly 2 decades in uniform, and earned a medical degree paid for by the military. In May of 2009, just 6 months before the shooting, he was promoted to major. By that point, co-workers and supervisors had already begun to notice a shift in him. He had been assigned to deploy to Afghanistan for the first time in his career, and he was making it clear to anyone who would listen that he did not want to go. In the months leading up to the attack, Hassan had been exchanging emails with a radical American-born cleric named Anwar al-Awlaki, who was living in Yemen and would later be killed by an American drone strike. Intelligence agencies had intercepted the messages. They had read them, and for reasons that would be argued over for years afterward, no one acted on them. The Soldier Readiness Processing Center at Fort Hood is where troops complete paperwork and medical screenings before deploying overseas. On the afternoon of November 5th, it was full of soldiers preparing to leave for Iraq and Afghanistan. Hassan arrived in his uniform, took a seat near a row of cubicles, then stood, shouted a religious phrase in Arabic, and began firing. He targeted soldiers in combat uniform and largely avoided the civilians in the building. One of the victims, a civilian physician assistant named Michael Cahill, threw a chair at him in an attempt to stop the shooting. Cahill was 62 years old and did not survive. Another victim, a 21-year-old private named Francesca Velez, was pregnant. She did not survive either. The shooting was ended by a civilian police sergeant named Mark Todd, who exchanged fire with Hassan and struck him multiple times. Hassan survived the encounter, but was left paralyzed from the waist down. The dead included officers, enlisted soldiers, a civilian medical worker, and a mix of active duty personnel from across the branches. Among them were Captain John Gaffney, Specialist Frederick Green, Major Libardo Caraveo, Staff Sergeant Justin DeCrow, Specialist Jason Hunt, Sergeant Amy Kruger, Private First Class Aaron Nemelka, Private First Class Michael Pearson, Captain Russell Seeger, Lieutenant Colonel Juanita Warman, and Private First Class Kam Xiong. Most of them had never seen combat. Some had only been in the Army a matter of months. How does a military psychiatrist, entrusted with the mental health of American soldiers, become the perpetrator of the worst mass shooting the American military has ever seen on its own soil? Hassan's court-martial did not begin until the summer of 2013, nearly 4 years after the attack. Part of the delay was consumed by a lengthy dispute over whether Hassan would be allowed to keep his beard while in custody, a fight that eventually reached the appellate courts. When the trial finally began, Hassan chose to represent himself. He called no witnesses in his defense. He offered no meaningful closing argument. On August 23, 2013, a panel of 13 senior officers convicted him on all 13 counts of premeditated murder, and 32 counts of attempted premeditated murder. 5 days later, on August 28th, the same panel sentenced him to death. They deliberated for less than 2 hours. The years that followed were consumed by the standard cycle of military capital appeals. The Army Court of Criminal Appeals reviewed the case. The Court of Appeals for the Armed Forces reviewed it. On March 31st, 2025, the United States Supreme Court denied Hassan's petition for review, closing out his direct appeals. That September, the Secretary of War, Pete Hegseth, publicly announced that he was pushing for presidential approval to carry out the execution. A Pentagon spokesman confirmed the case file was in staffing for the president's consideration. As of 2026, Nidal Hassan remains on military death row at the United States Disciplinary Barracks at Fort Leavenworth. Under the Uniform Code of Military Justice, his sentence cannot be carried out without the personal signature of the sitting president. No American service member has been executed since April 13, 1961. Whether Hassan will be the man to end that streak rests entirely with the White House. The waiting Hassan is doing at Fort Leavenworth is not unusual. He is not, in fact, the man who has waited the longest. That distinction belongs to a former Army cook from Fayetteville, North Carolina, whose case began more than 20 years before Hassan ever put on a uniform. Ronald Gray. In the winter of 1986 and into the spring of 1987, a series of violent attacks began in Fayetteville, North Carolina, in the shadow of Fort Bragg. Women were being abducted, assaulted, and killed. A cab driver went missing on a routine fare. A young Army private disappeared on her way back to base. A university student was found dead in a wooded area outside town. For months, local police and Army investigators worked their cases separately, unaware that they were chasing the same suspect. But when the connection was finally made, the trail led directly to a young Army cook stationed at Fort Bragg, home to the 82nd Airborne Division and one of the busiest posts in the American military. His name was Ronald Adrian Gray, and nearly 4 decades after he was first sentenced to die, he is still on military death row, longer than any other man in American military custody. Ronald Gray was born in the mid-1960s and enlisted in the Army as a young man. By the middle of the 1980s, he was stationed at Fort Bragg, working in food service for the 82nd Airborne Division. To anyone who met him casually, he was unremarkable. He wore the same uniform as thousands of other soldiers on the post, kept the same schedule, drew the same paycheck. Prosecutors would later describe him as a man who had been hiding in plain sight. The first of the killings attributed to Gray took place on December 15, 1986. Private Laura Lee Vickery Clay, an 18-year-old soldier, was abducted, assaulted, and shot 4 times. Her body was found in a remote area outside Fayetteville. 3 weeks later, on January 6, 1987, a Fayetteville cab driver named Kimberly Ann Ruggles picked up a fare and never returned. She was found stabbed to death. Around the same period, a 23-year-old Campbell University student named Linda Jean Coates was killed, and an 18-year-old woman named Tammy Wilson was killed as well. Gray also attacked another young soldier, Private Mary Ann Lang Namath. He stabbed her repeatedly and left her for dead. She survived, and she would later testify against him in court. The break in the case came from a combination of surviving victims, witness accounts, and physical evidence tying Gray to more than one crime scene. When investigators put a map on the wall and began plotting his movements against the locations and times of the attacks, the pattern that emerged was overwhelming. He was arrested in 1987 and charged in both North Carolina State Court and in the military justice system. In an installation that housed tens of thousands of active duty personnel and their families, how did a serial predator move freely for months without being identified? Gray's general court-martial began at Fort Bragg in December of 1987 and ran through April of the following year. He was convicted on 12 charges, including 2 premeditated murders and the attempted murder of Private Namath. On April 12, 1988, the military panel unanimously sentenced him to death. Separately, in North Carolina State Court, Gray pleaded guilty to the additional civilian killings. He was given 8 life sentences, 3 of them to be served consecutively and 5 concurrently. The state proceedings ensured that even if his military death sentence were ever overturned, he would still never leave prison alive. For the next 20 years, Gray's case moved slowly through the military appellate courts. On July 28, 2008, President George W. Bush approved the death sentence, clearing the final political hurdle for execution. A date was set for December 10, 2008. But 2 weeks before that date, on November 26th, a federal judge in Kansas issued a stay of execution to allow further review of Gray's legal claims. The case remained in that suspended state for years. In 2016, the stay was lifted. The Army Court of Criminal Appeals denied his petition. On June 28, 2018, the United States Supreme Court declined to hear his appeal. Since then, procedural motions and jurisdictional disputes have kept the case bouncing between military and federal courts, with no execution date rescheduled. Today, more than 37 years after that April sentencing, Ronald Gray remains at Fort Leavenworth. He has been on military death row longer than any other inmate in the system. Among the men currently condemned by the American military, he is widely considered to be the one closest to actually being executed. Like Hassan, his fate depends on the signature of a president who has not yet given one. Where Gray's crimes played out over months in the woods and back roads of North Carolina, the next case involved an attack that lasted only a few minutes and took place on the other side of the world in the opening hours of a war. Hassan Akbar. On the night of March 23, 2003, American soldiers of the 101st Airborne Division were sleeping in their tents at Camp Pennsylvania in northern Kuwait. The invasion of Iraq was hours away. The camp was ringed with wire, guards were posted at the perimeter, and every weapon was accounted for. Just before 1 in the morning, 3 grenades exploded inside 3 separate tents. Moments later, a soldier standing in the darkness outside opened fire with a rifle at anyone who tried to escape. The attacker was not an insurgent, not a spy, not an outsider who had slipped past the guards. He was an American sergeant, a Muslim convert from California, and he had planned the attack himself. Hassan Karim Akbar was born Mark Fidel Cools in April of 1971. He converted to Islam and legally changed his name years before he joined the Army. By 2003, he was assigned to the 1st Brigade of the 101st Airborne, part of the massive American force staging in Kuwait for the invasion of Iraq. In the weeks leading up to the attack, he had told fellow soldiers he was uneasy about what the Army was going to be asked to do, that he did not want to be part of an operation that would result in the deaths of other Muslims. When his unit was preparing to move north into Iraq, something in him decided. Akbar was assigned to guard duty on the night of March 23rd. That assignment gave him access to the ammunition point. He stole 4 fragmentation grenades. He also cut the electricity to the officers' area of the camp, then approached 3 tents and rolled or threw grenades inside. As soldiers ran out into the dark, disoriented and unarmed, He fired on them with a rifle. 2 men were killed. Army Captain Christopher Seifert, an intelligence officer, was shot in the back. Air Force Major Gregory Stone was killed by one of the grenades. 14 other soldiers were wounded, some of them severely. The chaos ended quickly. Akbar was captured within minutes of the last shot. When investigators interviewed him, prosecutors would later argue he made no serious attempt to deny what he had done. His stated goal, according to the government's case, was to inflict maximum casualties before his unit could deploy forward. What pushes an American Army sergeant, on the eve of a war he was ordered to fight in, to turn his weapons on the men sleeping beside him? Akbar's court-martial took place at Fort Bragg, North Carolina, and concluded on April 21, 2005, exactly 2 years after the attack, and on his own 34th birthday. He was convicted of 2 specifications of premeditated murder and 3 specifications of attempted premeditated murder. The panel that convicted him was made up of 9 officers and 6 senior non-commissioned officers, and the verdict was unanimous. 1 week later, on April 28th, the same panel sentenced him to death. Akbar became the first American soldier prosecuted for the murder of fellow soldiers during wartime since the Vietnam War. The case would echo through military legal circles for years after, cited in discussions about screening, about extremism inside the ranks, and about how command climates handle warning signs. His appeals moved somewhat faster than those of Gray or Hassan, but the outcome was the same. The Army Court of Criminal Appeals affirmed the conviction and sentence on July 13, 2012. The Court of Appeals for the Armed Forces affirmed on August 19, 2015. In October of 2016, the Supreme Court declined to hear the case, ending his direct appeals. Nearly 9 years later, in May of 2025, the Secretary of War formally awarded Purple Hearts to 9 of the veterans who had been wounded in the Camp Pennsylvania attack more than 2 decades earlier. It was a small acknowledgement of what had happened that night, one that had taken the better part of a generation to arrive. Hassan Akbar remains today on military death row at Fort Leavenworth. He is one of the 4 condemned men whose cases are being prepared under the Army's execution readiness plan. Like the others, his execution cannot proceed without the personal approval of the President. Akbar's attack took place in the days before the invasion of Iraq, but the American military had faced a nearly identical scenario on its own soil less than 8 years earlier. And the man who carried it out had told his fellow soldiers exactly what he was going to do before he did it. William Kreutzer, Jr. In the early morning of October 27, 1995, roughly 1,300 paratroopers from the 82nd Airborne Division were running in formation across Towle Stadium at Fort Bragg, North Carolina. It was a routine physical training session, the kind they had done hundreds of times. From a tree line about 150 yards away, a single soldier hiding in the underbrush opened fire with a rifle. Within minutes, 1 officer was dead and 18 more soldiers were wounded. And what would later disturb investigators the most was not the attack itself, but the discovery that the shooter, a fellow paratrooper from the same brigade, had told other soldiers exactly what he was going to do days before he did it. William J. Kreutzer, Jr. was a sergeant assigned to the 325th Airborne Infantry Regiment, part of the 2nd Brigade of the 82nd Airborne Division. By all outward appearances, he was an average enlisted soldier. Behind that facade, according to testimony that surfaced in the aftermath, he had spent months speaking openly about his hatred of his fellow paratroopers, about how much he wanted to hurt them, about specific plans to open fire on his own unit. Multiple people in his chain of command later admitted they had heard him say these things. None of them had passed it up the chain as a threat. On the morning of the attack, Kreutzer took up a concealed position in the woods overlooking Towel Stadium and waited. When the formation began its run, he opened fire from cover. Soldiers scattered. Some threw themselves flat on the pavement. Others sprinted for the far side of the stadium. A small group of special operations soldiers who happened to be nearby moved toward the sound of the gunfire, located Kreutzer's position, and tackled him before he could keep shooting. When it was over, one officer had been killed. Major Stephen Mark Badger, an intelligence officer, died from his wounds. 18 other soldiers had been hit. Some would go on to recover fully. Others would carry the physical and psychological effects of that morning for the rest of their careers. How many people had to hear a soldier openly plan to kill his own unit before somebody in the army treated it as a threat instead of a joke? Kreutzer's court-martial began in 1996. He was convicted of 1 count of premeditated murder and 18 counts of attempted murder. On June 13, 1996, the military panel sentenced him to death. He became one of only a handful of men on American military death row at the time. But the case did not end there. On appeal, his defense argued that his original trial counsel had been ineffective, that mitigating mental health evidence had been improperly excluded, and that the jury had been prevented from hearing testimony that might have supported a life sentence rather than death. In August of 2005, a decade after the attack, the Court of Appeals for the Armed Forces agreed. His death sentence was set aside, and the case was sent back for a new sentencing hearing. Kreutzer's retrial began in 2009. This time, he entered a plea of guilty. On March 24, 2009, the military judge, Colonel Patrick Parrish, sentenced him to life in prison. Along with the life sentence, he was reduced in rank to the lowest enlisted grade, ordered to forfeit all pay and allowances, and given a dishonorable discharge. He would never leave military custody, but he would also never be executed. More than 3 decades after the shooting at Towel Stadium, William Kreutzer Jr. is still incarcerated at the United States Disciplinary Barracks at Fort Leavenworth, serving out his life sentence. The soldiers who survived the attack, the widow of the officer he killed, and the families of the wounded, watched him come within a formal appellate ruling of the execution chamber, and then simply disappear behind the walls of one of the most secure prisons in the country. The pattern of a soldier turning his weapon on the men around him is one the American military has been forced to confront more than once. But the next case moved that violence out of a training field in North Carolina and into a combat stress clinic in Baghdad at the height of the Iraq War. John Russell. On May 11, 2009, an Army Staff Sergeant named John Russell walked into the Camp Liberty Combat Stress Center in Baghdad for a scheduled counseling appointment. He was a communications specialist with the 54th Engineer Battalion. He was 44 years old. He was on his 3rd tour in Iraq. By every account of the people who had spent time with him in the weeks leading up to that morning, he was a man in crisis. What happened over the next hour would become one of the worst incidents of soldier-on-soldier violence of the entire Iraq War, and it would raise serious questions about how the Army had allowed him to remain in the country, in uniform, and anywhere near a weapon. John Russell was from Sherman, Texas. He had spent most of his adult life in the Army. By his 3rd deployment to Iraq, colleagues and supervisors had watched him deteriorate. He was struggling with sleep, with concentration, with paranoia. He had been referred to mental health care. His personal weapon had already been taken from him as a precaution. By the morning of May 11th, he was not, functionally, a combatant. He was a patient inside a war zone. The appointment at the Combat Stress Center did not go well. Russell was reportedly angry, confrontational, and unresponsive to the clinicians who spoke with him. Afterward, He was placed in the vehicle of a fellow soldier for the drive back to Camp Stryker. During that drive, Russell overpowered his escort, took the man's rifle, and turned the vehicle around. He drove back to the clinic he had just left. He walked in through the same door, and he opened fire on the unarmed doctors, counselors, and patients inside. When the shooting ended, 5 American service members were dead. Specialist Jacob Barton, a 20-year-old, was killed. Sergeant Christian Bueno Galdos, 25, was killed. Major Matthew Housel, a 54-year-old military officer, was killed. Private First Class Michael Yates, 19 years old, was killed. And Navy Commander Charles Springle, a Navy officer serving alongside the Army medical staff, was killed. The man investigators later concluded Russell had come back to kill Colonel Michael Jones, escaped the clinic through a window. Why was a soldier already flagged as a mental health risk, whose personal weapon had already been taken from him, placed in a vehicle with an armed escort and a loaded rifle within his reach? Russell was taken into custody at the scene. Because the attack had occurred in a combat theater, his case moved through the military justice system rather than through a civilian court. Prosecutors initially considered pursuing the death penalty, but as part of a plea agreement, that option was taken off the table. Russell entered a plea of guilty. Military Judge Colonel David Kahn presided over the proceedings, which took place at Joint Base Lewis McChord in Washington State. On May 16, 2013, 4 years after the shooting, Russell was sentenced to life in prison without the possibility of parole. He was reduced in rank, given a dishonorable discharge, and ordered to forfeit all pay. Within days, he was transferred to Fort Leavenworth. Russell's family, along with the families of some of the men he killed, would spend years arguing that the Army bore partial responsibility for what happened at Camp Liberty. They pointed to the number of consecutive deployments Russell had served, to the failures of the mental health system that had been treating him, and to the decision to allow him to remain in an armed unit at any point after his condition had been flagged as a danger. The Army made a series of policy changes in the aftermath of the case regarding weapon control around service members in mental health treatment in combat theaters. In 2026, John Russell remains at the United States Disciplinary Barracks at Fort Leavenworth. Because his sentence is life without the possibility of parole, there is no release date attached to his file. He will die in military custody. If you're enjoying this video and you're not subscribed yet, take a second to do so. It really helps the channel keep going. Dwight Loving. In December of 1988, a 20-year-old Army private stationed at Fort Hood, Texas, robbed 2 convenience stores in a single evening for less than $100 in cash. In the hours after that, he began flagging down taxi drivers. By the following morning, he had killed 2 of them and attempted to kill a third. When investigators finally caught up with him, he sat down in an interview room and gave a full videotaped confession. What he said in that interview about why he had done it would become the centerpiece of the prosecution's case against him. His name was Dwight Jeffrey Loving. He was sentenced to death by a military court in the spring of 1989. Decades later, one of the final acts of a sitting United States president would erase that death sentence. Dwight Loving was born in Rochester, New York, in the late 1960s. He enlisted in the Army as a young man and was assigned to Fort Hood, then the largest single-post Army installation in the United States. By December of 1988, he was 20 years old. Nothing in his background and nothing in his brief military record would have predicted what he was about to do. On the night of December 11th and into the early hours of December 12th, Loving carried out what prosecutors would later describe as a spree of escalating violence. After the 2 convenience store robberies, he began flagging down cabs in the area around Fort Hood and Killeen. His first victim was Private Christopher Fay, a 20-year-old active-duty soldier who was moonlighting as a taxi driver to make extra money. Loving shot him twice in the back of the head. His second victim was Bobby Jean Charbino, a 44-year-old retired Army sergeant who was also driving a cab. Loving shot him in the head as well. The third driver, a man named Howard Harrison, refused to become the third victim. When Loving pointed the weapon at him, Harrison fought back, disarmed him, and escaped. It was Harrison's description that would allow investigators to identify Loving and track him down. During the interview that followed his arrest, Loving admitted to the killings on tape. According to the court record, he told investigators that he had killed the first driver to see whether he could get away with it, and that he had killed the second one because he had enjoyed it. The prosecution treated the confession as uncontested at trial. What pushes a soldier with no prior criminal record from a pair of low-dollar convenience store robberies into a series of premeditated killings of complete strangers in the span of a single evening? Loving's general court-martial was convened at Fort Hood. He was tried under Article 118 of the Uniform Code of Military Justice on charges of premeditated and felony murder. An 8-member military panel convicted him on all counts. On April 3, 1989, the panel sentenced him to death. He was transferred to Fort Leavenworth to await execution. His case would take on an importance far beyond his own fate. His appellate attorneys challenged the constitutionality of the entire military death penalty, arguing that only Congress, not the President, could establish the specific aggravating factors that made a service member eligible for execution. In 1996, the United States Supreme Court decided the case of Loving versus the United States. The court ruled against him and upheld the military death penalty in a decision that would go on to be cited in every capital case that followed in the American military justice system. But Loving's own sentence would not survive. On January 17, 2017, 3 days before he left office, President Barack Obama commuted Loving's death sentence to life in prison without the possibility of parole. The commutation was conditioned so that Loving would never be eligible for parole, sentence remission, or any related federal benefit. He was removed from military death row and placed among the other inmates serving life sentences at Fort Leavenworth. Today, Dwight Loving is alive. He is serving life without parole at the United States Disciplinary Barracks. He has no execution scheduled and no legal path to one. He is one of a small handful of former military death row inmates whose sentences were reduced through the exercise of presidential clemency, and the case that bears his name still governs the process by which any other condemned service member can be executed in the American military. Loving's commutation came from the desk of a departing president. But another sentence in the same category, a death sentence handed down by the only Air Force court-martial in more than a decade to impose one, was set aside not by clemency, but by an appellate court that concluded the original defense had failed him. Andrew Witt. On the night of July 5, 2004, an Air Force senior airman drove up to a small house on Robins Air Force Base in central Georgia, walked to the front door in his battle dress uniform, and knocked. He was carrying a knife. Inside were 3 people, another airman, that airman's wife, and a friend who had come over earlier in the evening to help mediate a personal dispute. Within the next few minutes, 2 of the 3 would be dead, and the third would be badly wounded, but alive. The killer was an avionics technician from southwest Wisconsin named Andrew Paul Witt. He would become the first airman sentenced to death by a military court in more than a decade. 14 years later, another military court would erase that sentence. Andrew Witt was a senior airman assigned to Robins Air Force Base, a maintenance and logistics hub the Air Force operated in central Georgia. He was, by the accounts that came out at trial, a young man in a technical job, well liked by some of his colleagues and not particularly close to others. In the summer of 2004, he became entangled in a personal dispute with a fellow airman named Andrew Schleipzig and Schleipzig's wife, Jamie. The dispute began earlier in the day, when Jamie Schleipzig reported to her husband that Witt had made an unwanted sexual advance toward her. Her husband confronted Witt about it by phone. During that call, according to the trial record, the husband and a friend allegedly threatened to report a separate affair Witt had been involved in. That evening, something in Witt shifted. He changed into his battle dress uniform, took a knife, and got into a vehicle. He drove to the Schleipzig home. What happened inside the house lasted only a few minutes. Andrew Schleipzig was stabbed to death. His wife Jamie was stabbed to death. The friend who had come over that evening, Senior Airman Jason King, was stabbed and left for dead, but survived his wounds. He would eventually recover enough to testify against Witt in court. When Witt was arrested and interviewed by investigators, he made a confession that would become the centerpiece of the prosecution's case. According to the trial record, his intent that night had been to leave no witnesses. What could push an airman with no meaningful criminal history, in a routine technical job on a routine Air Force base, to the point of putting on his uniform, picking up a knife, and driving to a colleague's home with the stated goal of leaving no one alive? Witt's court-martial began at Robins Air Force Base in 2005. He was tried capitally, meaning the panel could impose a death sentence if it convicted him of the most serious charges. It did. He was convicted of 2 specifications of premeditated murder and 1 specification of attempted premeditated murder, and he was sentenced to death. It was the first death sentence handed down by an Air Force court-martial in 15 years, and it made Witt, at least for a period, the only member of the Air Force awaiting execution anywhere in the American military system. His case moved into appellate review. His defense team argued that the lawyers who had represented him at his original trial had been ineffective, that they had failed to introduce mitigating evidence that could have changed the outcome at the sentencing phase, and that the trial had been fundamentally compromised as a result. The appellate courts agreed. Witt's death sentence was set aside, and the case was sent back for a new sentencing hearing. The resentencing panel convened on July 6, 2018, exactly 14 years and 1 day after the killings. This time, the panel did not impose death. Witt was sentenced to life in prison without the possibility of parole. He was reduced in rank to the lowest enlisted grade, ordered to forfeit all pay and allowances, and given a dishonorable discharge. The Air Force Court of Criminal Appeals affirmed the new sentence on November 19, 2021. On June 5, 2023, the Court of Appeals for the Armed Forces affirmed by a vote of 4-1. In his dissent, the Chief Judge wrote that trial counsel had irredeemably compromised the entire sentencing process. Late in 2023, Witt filed a petition for review with the United States Supreme Court. Andrew Witt is now serving life without the possibility of parole at the United States Disciplinary Barracks. He is no longer on military death row. The Air Force, which for years had a single airman waiting for execution, no longer has one. Witt's case was decided inside a military courtroom, litigated over the course of more than a decade, and eventually resolved in a way most people outside the military justice system will never hear about. The next case was different. It was on the front page of every newspaper in the world for months, was debated in Congress, was raised in United Nations sessions, and did lasting damage to the reputation of an entire branch of the American military. Charles Grainer, Jr. In the fall of 2003 and the winter of 2004, a series of photographs began circulating inside a military prison in Iraq. They showed naked detainees stacked into a pyramid, detainees hooded and standing on boxes with wires attached to their fingers, detainees being led on leashes, and detainees being threatened with military working dogs. When the photographs finally leaked to the American press in the spring of 2004, the fallout reshaped the American conduct of the Iraq War, damaged the standing of the United States across the world, and led to the court-martial of a small number of low-ranking soldiers. The man identified as the ringleader of what happened in those images was an Army reservist and former Pennsylvania prison guard named Charles Grainer Jr. He was sent to Fort Leavenworth, and roughly 6.5 years later, he walked out. Charles A. Grainer Jr. was born on November 10, 1968, in Uniontown, Pennsylvania. Before his deployment to Iraq, he had worked as a corrections officer in the Pennsylvania state prison system. In 2003, he was mobilized as an Army Reserve corporal with the 372nd Military Police Company. He deployed to Iraq and was assigned to Abu Ghraib prison on the outskirts of Baghdad. Abu Ghraib had been infamous under the government of Saddam Hussein. Under American operation, in the aftermath of the invasion, it became a holding facility for thousands of detainees, most of them Iraqi civilians. The abuse that Grainer participated in, and according to the government's case, actively led, took place inside a specific cell block of the prison in late 2003. Detainees were forced to strip. They were arranged into physical formations for the camera. One detainee was struck hard enough to lose consciousness. Others were made to perform simulated sexual acts while photographs were taken. All of it was documented by the soldiers themselves. Grainer would maintain in his defense that he was following orders from military intelligence personnel who wanted the detainees softened up psychologically before formal interrogation. His superiors denied it. When the photographs reached the outside world in April of 2004 and were published by news outlets around the world, the political response inside the United States and internationally was immediate. The White House condemned the abuse. Members of Congress demanded accountability. Investigations were opened. Why did a group of American soldiers, operating a detention facility on behalf of the United States government, not only participate in the kind of conduct that international law prohibits, but photograph themselves doing it? Grainer's court-martial was the first of the Abu Ghraib cases to be tried. It was held at Fort Hood, Texas. On January 14, 2005, he was convicted of conspiracy to maltreat detainees, failure to protect detainees, assault, indecent acts, and dereliction of duty. He was sentenced to 10 years in military prison. His rank was reduced. He was given a dishonorable discharge and ordered to forfeit all pay and allowances. He was transferred to the United States Disciplinary Barracks at Fort Leavenworth to serve his sentence. He served roughly 6.5 years there. Under military corrections rules governing good behavior and credit for time served, he became eligible for release earlier than the full 10-year term. On August 6, 2011, Grainer was released from Fort Leavenworth. He remained under supervised release until December 25, 2014. Grainer had been the ringleader identified in the government's case, and he received the longest sentence of any of the Abu Ghraib defendants. He was also the last of them to be freed. His former fiancée, Lindy England, whose face became one of the most recognized images of the entire scandal, was convicted separately and released after a shorter sentence. Another co-defendant, Megan Ambull, later married Grainer. Today, Charles Grainer Jr. is a free man. His sentence has been fully served. His supervised release ended more than a decade ago. He is no longer under any form of military control. The military justice system did what it was designed to do in his case. He was tried, he was convicted, he was punished, and then he was released. Whether the punishment fit the scale of what happened at Abu Ghraib is a question that outlasted his sentence and remains open today. Greiner completed his term and walked out of Fort Leavenworth as a free civilian. The next man on this list also left Fort Leavenworth well before his sentence was up. But he was not released by the corrections office. He was released by an order signed at the White House. Clint Lawrence. In July of 2012, an Army first lieutenant had been in command of a rifle platoon in the Jari district of Kandahar province, Afghanistan, for exactly 3 days. On a morning patrol, 3 Afghan men appeared on a rural road, riding on a motorcycle, headed toward the platoon's position. The lieutenant ordered his men to open fire. 2 of the 3 were killed. When American investigators arrived at the scene, they found no weapons on the bodies. They found no weapons in the road. They found no explosives. What followed became one of the most politically charged war crimes cases in modern American military history, a case that split combat veterans against each other, drew in the highest levels of the United States government, and ended with the stroke of a presidential pen. His name was Clint Allen Lawrence, and today he is a licensed attorney practicing law in the state of Missouri. Clint Lawrence was born on December 13, 1984, in Hobart, Oklahoma. He commissioned as an Army officer and eventually joined the 4th Brigade Combat Team of the 82nd Airborne Division. He deployed to Afghanistan in 2012 and was placed in command of the 1st Platoon after its previous platoon leader had been wounded. He had been in charge of the unit for exactly 3 days when the incident on the road took place. According to the accounts that came out at his court-martial, the soldiers of 1st Platoon were on a routine patrol in a village of the Jari district when a motorcycle approached with 3 men aboard. Lawrence ordered his soldiers to fire. 2 of the riders, Afghan civilians named Haji Mohammed Aslam and Gamai Abdul Haq, were killed. The 3rd rider was wounded and escaped. In the immediate aftermath, Lawrence was accused of threatening villagers who had witnessed the shooting and of soliciting false statements from his men to justify the engagement in the after-action reports. The prosecution's most damaging evidence did not come from the Afghans. It came from Lawrence's own soldiers. 9 of the men under his command testified against him at the court-martial. They told investigators and the panel that the men on the motorcycle had posed no threat, that no weapons had been visible, and that Lawrence had ordered the fire mission without the tactical justification the reports later claimed. What made 9 of the soldiers Lawrence had been sent to lead willing to take the witness stand against him? And what did the Army eventually conclude about the officer they had put in charge of them? Lawrence's court-martial was held in 2013. He was convicted of 2 counts of unpremeditated murder, attempted murder, wrongfully communicating a threat, reckless endangerment, soliciting a false statement, and obstruction of justice. He was sentenced to 20 years in military prison, later reduced to 19. He was transferred to the United States Disciplinary Barracks at Fort Leavenworth, where he began serving his sentence. He served approximately 6 years of that sentence. In that time, his case became a cause célèbre in certain veteran and political circles. Advocates argued that Lawrence had made a defensible battlefield decision under conditions no civilian could understand. Opponents, including some of the men who had served under him, argued that the Army had gotten it exactly right, and that a pardon would send a signal that the rules of engagement did not matter. On November 15, 2019, President Donald Trump issued a full pardon for Lawrence. He was released from Fort Leavenworth that same evening. His military conviction was wiped out. He was no longer a prisoner and no longer subject to the discipline of the Army. He was a private citizen. What Lawrence did next surprised even people who had followed his case. He enrolled in law school. He graduated with a Juris Doctor from Appalachian School of Law in 2023. He sat for the Oklahoma bar examination in July of that same year, a decision that generated public objections from former members of his old platoon, who filed statements with the state bar arguing on character and fitness grounds that he should not be admitted to practice law. He was not admitted in Oklahoma. He was, however, admitted to the Missouri bar in 2025. He served briefly as an assistant public defender for the Missouri State Public Defender's Office in 2024 and 2025. In 2026, he holds the position of assistant county counselor in Jefferson County, Missouri, and operates his own private practice, Lawrence Law, out of Kansas City. He has published 2 books and has continued to pursue graduate study in law. Lawrence walked out of Fort Leavenworth under the signature of the President of the United States. The final man on this list walked out of Fort Leavenworth under nobody's signature at all, and it took the American military 37 years to catch up with him. James Robert Jones. In 1974, a young Army private stationed at Fort Dix, New Jersey, was convicted of murdering another soldier and wounding a second man in what began as a drug-related altercation on a road outside the base. He was sent to Fort Leavenworth to serve a 23-year sentence at what was then known as the Castle, the old stone fortress that had housed the military's most serious offenders since the 1870s. 3 years later, in 1977, he walked out. He was 23 years old, and he simply vanished. For the next 37 years, he lived openly in a small town in Florida, holding a job, paying bills, raising a life under a name that was not his. Then, in 2014, a piece of technology that had not existed when he escaped quietly caught up to him. James Robert Jones was born in 1954 in Ontario, California. He enlisted in the Army as a young man and was assigned to Fort Dix in the Pine Barrens of central New Jersey. On the night in question in 1974, another soldier, an 18-year-old private named Lonnie Eaton, was walking back to base from a nearby bar with a friend. According to reporting in the New Jersey press at the time, 3 men approached Eaton and his friend on the road. One of the 3 asked to buy marijuana. What began as that exchange escalated into a violent attack. Eaton was stabbed to death. His friend was wounded but survived. Jones was identified as one of the attackers. Jones was tried and convicted in 1974 of premeditated first-degree murder and aggravated assault. He was sentenced to 23 years in military prison. He was transferred to the United States Disciplinary Barracks at Fort Leavenworth, then still operating out of the castle, the original 19th century structure that had held military prisoners for a century. He served 3 years of the sentence. In 1977, at the age of 23, he escaped. According to Army records, he was last seen working in the prison's dining facility on the day of his disappearance. How exactly he got out was never publicly detailed. The Army placed him on its 15 most wanted list. Investigators worked the case. Leads went nowhere. Years went by. Then a decade, then 2, then 3. While the Army was looking for him, Jones was in Deerfield Beach, Florida. He was working for an air conditioning company. He had a wife. He was paying his taxes. He was living under the name Bruce Walter Keith. His neighbors had no reason to think he was anything other than what he presented himself to be. He had built an entirely new life, in plain sight, and had done so for what would eventually amount to nearly 4 decades. How does a convicted first-degree murderer walk out of the most secure military prison in the country, drive south, take on a new name, get a driver's license, get married, hold a steady job, and stay hidden from federal investigators for 37 years? The answer, when it finally came, was a combination of old-fashioned police work and new generation technology. In the years since Jones had disappeared, the state of Florida had begun keeping digital records of driver's license photographs. Facial recognition software had improved to the point where an old photograph from a military mugshot could be run against a state database of license photos, looking for statistical matches. When U.S. Marshals fed Jones's 1974 mugshot into the system, it returned a match on a 1981 Florida driver's license issued to a man named Bruce Walter Keith. The technology did the work that 37 years of manual investigation had not. On March 13, 2014, U.S. Marshals arrested Jones in Pompano Beach, Florida. He was 59 years old. According to the officers who took him into custody, when they identified themselves and told him he was under arrest, he said he had known this day would catch up with him eventually. He offered no resistance. He was returned to Fort Leavenworth within days and, in the language of the Army Corrections Office at the time, was processed just like a new inmate. What happened to him after that has never been publicly reported. The Army did not announce whether he was charged with the additional crime of escape. There is no public record of a release date, no obituary, no news account of his continued incarceration or his death. If he is still alive today, he would be in his early 70s. Whether he remains at Fort Leavenworth, whether he has been transferred, or whether he has died in custody is a question that the open historical record does not answer. As of 2026, the only confirmed information about James Robert Jones in the public record is that he was returned to military custody in the spring of 2014, after nearly 4 decades of living a life that never should have been his to live. Whatever came after that, whatever quiet ending or continuing incarceration his case eventually received, has been kept where the military corrections system has always preferred to keep its most obscure inmates, out of the public eye. Every one of these 10 men is at Fort Leavenworth for a reason, and every one of their cases changed something about how the American military polices its own. Thanks for watching. Click here to see our next video.